Courts are not recovery agents. This was the observation made by Honorable Supreme Court in a recent judgment. The context of this observation is that many civil cases are being converted into criminal cases and settled once for all. Because if in a civil case there is no threat of going to jail, but in a criminal case there is every threat of going to criminal jail, going regularly to criminal court. In a civil case you don't need to go to court regularly. Only when you have to suffer cross-examination, you must appear in the court. Otherwise, there is no need to go to court. Unlike in a criminal case, you have to regularly go to court on every date. You have to take sureties for guaranteeing your appearance. And if you don't appear, warrant will be issued. So it is a headache to get entangled in a criminal case. Therefore, there is a threat of fear when a criminal case is filed. So what exactly happens is when you don't get the desired results in a civil case, you also file a criminal case. That's how a civil case is converted into criminal case. Parallelly, Supreme Court says that parallelly civil case and criminal case can run concurrently. So civil case will be there. It will be at its own pace, but criminal case will be at its own pace, which is quite faster, and there's a lot of pain associated with the filing of a criminal case and trial of a criminal case. Therefore, citizens or some intelligent people who think intelligent, they are intelligent, file criminal case also along with the civil case. Just filing a criminal case doesn't solve the purpose, because you can immediately approach High Court and get it quashed. So there is always a remedy when a criminal case is filed. There are many safeguards against filing a criminal case also. But you can still convert a civil case into a criminal case. To some extent, Supreme Court is always correct, but there are some exceptions. And what are that exceptions? In a civil case, the basic difference between a civil case and a criminal case is that in a civil case, there is no intention to commit or cause damage to somebody, to commit an offense or cause damage to somebody. But in a criminal case, there must be an intention to commit an illegal act. The citizen or the offender must know that prior to commission of the act that it is illegal. Then only it is a crime. This is one dimension of a criminal offense. The other dimension is omission of a legal duty. You must understand this very carefully. Omission of a legal duty is also a criminal offense. Commission of an illegal act is also a criminal offense. For an omission of a legal duty, the example is, suppose you are driving a car. It is your legal duty. It is written in the law that you must drive very carefully. You must drive with responsibility. You must drive with caution. Otherwise, citizens' lives are at stake, will be at risk. They will suffer, they will die. Your vehicle is a murder weapon if you don't handle with care, caution and responsibility and obligation. So therefore, you are driving a car. If you omit the legal duty to drive carefully, it is a criminal offense. That is why when accidents happen, criminal case is registered. And direct offense, you already know, the offense is like, you are trying to cause harm to somebody, then it is a direct offense. It is you know that that killing somebody or hurting somebody is an offense, is an illegal act. If you are above 18 years, you will definitely know what is an illegal act. So therefore, there could be many examples for omitting a legal duty, like doctor trying to omit a legal duty, doctor trying to perform some operation without care, caution and responsibility is omission of a legal duty. That is to say, a legal duty must be written in the law. If that is written in the law, it is a criminal offense. So you have to prove, the person who is complaining against the doctor has to prove that doctor failed to act with care, caution and responsibility. Then it is a criminal offense. Otherwise, intention must be there. If accident is happening, I will not say somebody met with an accident. I will say accident is happening, because you don't meet with an accident. If an accident or if you suffer an accident, the driver did not act with care, caution and responsibility. It is your duty to prove, and it is the driver's offense to disprove your theory that he acted with care, caution and responsibility. The driver has to prove that you are not following traffic rules. You also did not act within your duties. You also failed to perform your duty. That is from the driver's defense or the driver's point of view. And what is your point of view? You have to prove that driver failed to act responsibly in accordance with the law, in accordance with the traffic rules. The same is with doctors. Now coming to the point, what if it is not written in the law that you have to perform a duty? For example, somebody drowning in a river. You are beside a river and there is a lifeguard, and the lifeguard has a duty to perform. Lifeguard is sleeping, lifeguard is not there, or lifeguard is at that point of time not available. You know swimming, but you are not trying to protect the person who is drowning because you have your own fears about life, or you're not adept with swimming or saving other people's life, or in other words, you are not an expert. That is not an offense because you have no legal duty to perform. You have to understand this point. The omission of a legal duty to perform is a criminal offense. So if you want to convert a civil case into a criminal case, you must always check whether there is a legal duty to perform against the person whom you are trying to file a criminal complaint. Contractual obligations, private contract obligations, duties, responsibilities they are not statutory duties. They are not duties in accordance with law. Law did not create that duty. It is a duty created by contract. Two persons are sitting together and writing a contract. It is a terms and conditions agreed between them. They are bound to fail, or they can be, the purpose of writing a contract is a damage control exercise. What if the contract fails? What to do when a contract fails? That is the purpose of writing a contract. Otherwise, what is the purpose of writing a contract? So when a contract fails, when the terms and duties in a contract are not performed, when a private contract are not performed, then that is not a criminal offense. That is why promise to pay at the time of entering a contract is not an offense if you default. It is a civil liability because it is a contract between two persons that you promise to pay, and you don't have any intention to default at the time of taking a loan from somebody. So therefore, it is not a criminal offense. Sometimes civil cases or recovery cases, they are filed at the police station as a criminal case. They go to High Court, quashes them. Simple. It is simple because there is no duty to perform. There is no omission. Forget about commission of an illegal act. Undoubtedly, commission of an illegal act is a criminal offense. There is no second thought about it. There is an intention to cheat, then it is a criminal offense. In recovery of money cases also, if there is an intention to cheat at the time of taking a loan, if you could prove that in your complaint, then you have a case. So therefore, if you want to convert a civil case into a criminal case, you have to look all these aspects. Then only you can convert a civil case into a criminal case. And then court can act as a recovery agent. Otherwise, court will not act as a recovery agent. Court will throw that complaint out. I think I explained it in detail. Thank you. Thanks for watching. If you have any doubts, kindly comment.